Hello, everyone. Hope everybody can hear me. We're gonna give it a few more minutes here, unless everybody appears to be here. If somebody's waiting on somebody, you can yell out, I guess.
I believe everybody's here for the division.
Thanks, Jeff. Is there anyone that we're missing? Anyone obvious that we're missing, I guess?
I'm sorry. Everyone here for the applicant is present.
Thank you. Does it look like everybody's here representing the objector? Good to go? Okay. Well, we can go ahead and get started here. This is the pre-hearing conference for Albert Fry & Sons Walstrum Quarry, division permit number M 1983-033. It's a 112C permit amendment application number 9. And my name is Jason Music. I'm a senior environmental protection specialist with the division. I'll be representing the Mineland Reclamation Board for this pre-hearing conference, and I will be the pre-hearing conference officer. So real quick, I'd like to go through and do a few introductions on who's on the call. You can introduce yourself and your role in the process, and we will start with Chuck Koyman.
Hey everyone, I'm Chuck Koyman. I'm the Assistant Attorney General, counsel to the board, and also counsel to the pre-hearing officer in this meeting. Thanks.
Thanks, Chuck. Could the division staff introduce themselves, please?
Sure. Russ Means, I'm the Minerals Program Director.
I'm Jared Ebert. I'm a Senior Environmental Protection Specialist with the division.
I am Peter Hayes. I am the Environmental Protection Specialist assigned to this project.
I'm Zach Trujillo. I assisted in the review of this application for the division.
And then Attorney General representative?
I think we had one more. I think, Patrick, are you on? Oh, he's connecting now.
He just he got disconnected. So.
All right. Jeff Fugate's here on behalf of the division with the Attorney General's office.
Thanks, Patrick. You want to introduce yourself?
I'm Patrick Lindberg with the Division of Reclamation, Mining, and Safety. I assisted Peter Hayes with this.
Thanks, Patrick. And now we can move on to the applicant.
This is Joelle Bolduck. I'm the Land Environment Manager at Albert Fry & Sons, and I prepared the application with assistance from many others.
Thanks, Joel.
Good morning. My name is Albert Fry Jr., president of Albert Fry & Sons, and was the lead on this amendment process. Thank you.
Good morning. This is Becky Rigo. I'm in-house counsel for Albert Fry & Sons.
Good morning. I'm Steve O'Brien with Environment Inc., consultant to Albert Fry & Sons.
And I'm Tom Hessman. I'm a senior hydrogeologist and engineering geologist with Tetra Tech.
And I'm Fred Charles. I'm senior engineer with Tetra Tech, and I'm the project manager on this.
One microphone.
I'm Pam Hora. I'm a planner with Tetra Tech.
Thanks, Pam. Is that it for the applicant? Got a lot of names on my screen, so I don't want to miss anybody.
Yes, that's everyone with the applicant. Thank you.
Okay. And now let's go to the objector and their party. I mean, and their.
Good morning. This is Mark Lasis with the law firm of Ireland, Stapleton, Pryor and Pascoe. My colleague, Mamie Ling, is also on the Zoom call, and we represent the objector, Robert Young and Young Ranch East LLC.
Thanks, Mark.
And both,
I'm Bob
both
Young.
Ms. Ling and Mr. Young are on the call as well.
I'm Bob Young, and I'm the objector.
Thanks, Bob. I think that's everyone. Did I miss anybody that's on the call? No? Okay. Great. So we can get started here. I just want to go over a little bit on the purpose of this pre-hearing conference and kind of the objectives of what we want to do today. The primary purpose is to, we want to describe and provide an overview of the amendment process. The division staff will provide that overview of the dates, objections received, those kind of things with the amendment process. We want to identify the party to this matter. We want to also explain the rights and responsibilities of the party. We would also like to identify and discuss any issues to the extent possible that we can. And then we also are going to finally establish the Mineland Reclamation Board hearing process. And that involves proposing the list of jurisdictional items that the board will hear. We're going to attempt to simplify these issues if we can during this pre-hearing conference. And finally, we're going to establish timeframes and orders of how the hearing on this matter will proceed in terms of timing and when the parties will speak to the board. At the conclusion of the pre-hearing conference, we will do what is called a pre-hearing order, and it'll be a draft order. That's an order, that order is a draft simply because the board can adopt the draft as we decide here today, or they do not have to. They could amend that draft if they want before it's finalized and voted on at the board. The Attorney General representative for the division will propose the order that we agreed on here today and ask the board to adopt it. The pre-hearing conference order will primarily discuss 4 things. It will be the hearing process, how the board's going to hear this item, all parties involved, who the parties are, the issues that will be heard in front of the board, and the proposed schedule that we decide on here today in terms of order and timing on how the board will hear it. So are there any questions on that draft pre-hearing order? And I'll discuss a little bit more about that in terms of timing, when it will go out to all the parties and what will be in it a little later. From what I understand, we'll go through the parties, and it's my understanding that one party has been identified by submitting a timely objection within the 20 calendar days of the date of the newspaper publication, Mr. Bob Young. But it is noted that the division did receive some untimely objections. Those objections were received greater than 20 days after from, I believe, the 46 individuals and other entities. However, they were not identified as parties in this matter. Part of being a party means that the party must attend this pre-hearing conference, which you have, or be presented by a proxy, which doesn't matter. And the party must attend the public hearing later on this month. As a party, you have certain rights and responsibilities. At the board hearing, anybody identified as a party can present evidence. They can call witnesses. They can cross-examine other parties' witnesses, and they may be represented by an attorney. In addition, a party has the right to sue or be sued in district court on matters surrounding any application's review and the board's decision. And only parties to this hearing may seek judicial review of a board decision. So that's kind of a little bit of the rights and responsibilities of the one party. Mr. Young, do you guys have any questions on the rights and responsibilities of the party that I can answer, or one of the attorneys? Pretty clear. Good deal. So now I'm going to give you a few dates associated with this, and they're involving motions. So, one thing I do want to mention, sorry, I omitted a little bit. If a party wishes to withdraw as a party, you must do so in writing prior to the commencement of or on the record during the board meeting. I do want to throw that out there. However, even if choosing not to be a party or to withdraw your party status, you may still address the board on any matters of concern, but you will not be entitled to the rights of a party. So moving on to motions. Parties wishing to file motions must do so no later than 5 p.m. on November 8th, 2021. And that's basically, motions must be received by the board secretary no later than 2 working days following this pre-hearing conference. So that's basically 2 working days is November 8th, because the weekend. I'm good on those dates, right, Chuck? I mean, I think that's the date. Because of the weekend, it moves over to Monday. Yeah. Those motions will be filed with Cami Mohar, the board's secretary. I believe you all have her email. If you don't, you can shoot up your hand and I'll read that email out to you. But I think that you guys would probably be in communication with her on the board matter. Responses to any motions filed must be received no later than 5 p.m. on November 12th. And that's going to be 3 working days prior to the board hearing date. So that's that November 12th date by 5 p.m. Any questions on those 2 dates in terms of motions that we filed? No, good. As far as materials for hearing, I received some materials from the objector, Bob Young, today. So we're good on that. We received those today, November 4th, that had potential witnesses as well as list of exhibits. So I appreciate that. Does the applicant have anything that's not in the division files that they'll be submitting in terms of witness lists or exhibits?
The officer, we actually just submitted ours at a few minutes ago before the hearing started. So they've
Great.
been
Great.
And Mr. Music, if I can just ask a clarifying question about the motions, they have to be served on Cami via email. Can those also be served on the parties via email as well? I'm assuming we're doing all of this.
Yeah, let's do it.
There's no hard copies.
Yeah, thanks, Jeff. Yeah, we can do everything via email. So back and forth with between the parties. Nothing needs to be done hard copy.
And hey, Jason, just for everybody's clarity, it's probably going to be easiest for us to keep track of it if when you serve anything on Cami that you just copy all the parties on that email. That way we know service has been accomplished at the same time that the board administrator gets it.
Yeah, thanks, Chuck. So that's kind of a overview. I think at this point we'll have division staff kind of summarize the permitting proposal and the review process. And you can also include any discussion of any kind of attempts to resolve issues, that kind of thing. So I'll turn it over to division staff.
Hey, Jason. Again, this is Peter Hayes with the division. As I stated, this is the pre-hearing conference for the Walstrum Quarry Amendment Application number 9. It's file number M1983-033, and the operator is Albert Fry and Sons Incorporated. The amendment application was received by the division on April 20th, 2021. On May 11th, 2021, the application was called complete and filed for review. On May 12th, the division deemed the application complex, therefore extending the review period by 60 days. The Walstrum Quarry is located 4 miles east of Idaho Springs, Colorado in Clear Creek County. The proposed Walstrum Quarry amendment would add 464.17 acres to the existing 285.13 acre site, increasing the total permanent acreage to 749.3 acres. The primary commodity to be mined would be granite for construction aggregate. On June 20th, the division conducted the required pre-operational inspection for the amendment application. Also on June 20th, the division received 1 timely objection letter from Mr. Young. On June 29th, 2021, the public comment period closed for the amendment application. The division staff, myself and 3 other specialists reviewed the application, and we issued 6 advocacy letters. All advocacy concerns have been addressed by the applicant. On October 21st, the division held an informational public meeting for the amendment application. The proposed post-mine land use is wildlife habitat, privately owned natural resource area, industrial commercial development, and developed water resources. The financial warranty was calculated at $1,100,000 by the division. This is an increase of $358,000 from the currently held warranty. That concludes my summary, unless anyone else has any questions.
Great, thanks, Peter. So right now, I think I want to get into the summary of issues. From what I understand, the division put together a rationale that included 5 issues. I'm going to go over those issues and kind of just clarify to make sure that the objector understands the division's rationale in the rationale letter sent on October 29th and the characterization of each one of those issues. And I also want to make sure that the objector agrees with that characterization or doesn't agree, or if there's some common ground there, and kind of go from there. The first issue identified by the division in the objection letter was access easement concerns. Has there been any kind of resolution to those concerns based on the division's rationale? And does the objector still agree with that characterization by the division? And kind of where we stand on that. Is that an item the board will still, that the objector still wants the board to look at?
Yes, Mr. Music. there have been some intervening developments, namely a Court of Appeals decision that came out about a week ago, which expressly deals with the access easement issues. So we do intend to present evidence and testimony on the access easement issue. It has not been resolved.
Okay. And moving on to number 2, the division's characterization was effect on mining and reclamation on the stability of structures and making ground prone to slides. So same issue. Does the objector agree with that characterization? And where are we at in terms of any types of resolution?
Similarly, this is not resolved, and we intend to present evidence and testimony on this issue as well.
Okay, thank you. Number 3 was protection of utilities. Based on the division's rationale, where does the objector stand on the third item, protection of utilities?
We may touch on it briefly. It won't be a large portion of the presentation, but we're going to reserve the right to present some evidence and testimony with regard to this topic as well.
Okay. And then number 4 was the impact on hydrologic balance as it pertains to the use of groundwater for a potential future well on Mr. Young's 40-acre property.
This also is not completely resolved. So similarly with the utilities issue, it probably won't encompass a large portion of the presentation, but we'll reserve the right to present evidence and testimony on this as well.
Great. No chance of resolution here today, is what you're saying.
Unfortunately not.
Okay.
Unless the applicant wants to withdraw the application.
I don't see that happening. So let's move on to number 5. Number 5 was the division's characterization of mine waste handling. Where do we stand on this one?
This also is not resolved, so we'll reserve the right to present evidence and testimony on it.
Right. Okay. We have all 5 issues. Now, does this the division's rationale encompass the overall objections brought forth by Mr. Young?
Generally, yes. As indicated on our witness and exhibit list, which was filed this morning, there are additional issues. We're cognizant of the jurisdictional limits of the board. There are still certain areas of evidence and testimony with regard to air quality and traffic and failure to comply with laws and regulations in the past that are relevant for the board's consideration. So it's not necessarily a separate topic, but we just wanted everybody to be mindful that those issues will be addressed by both Mr. Young and then potentially by our 2 expert witnesses as well.
Sure. Okay. Yeah, just a reminder now that what the pre-hearing order will state will just be what the division determines as the jurisdictional issues that the board will hear. And so if there, I can't speak for the board, but I can tell you that if there's much deviation from what the division is deemed as jurisdictional in this board hearing, it's up to the board to hear those items or not. So, the board feels like air quality issues isn't a jurisdictional issue based on what the division looks at, then they might not hear it. So in terms of this board, this pre-hearing board order, we're just going to be listing the jurisdictional items. So you can bring forth whatever you want, I guess, to the board, but in terms of what's going to be in this letter, it's just going to be the jurisdictional issues.
Understood.
Okay, thank you. Okay,
Mr. Music?
Go ahead.
Before we move on from the objectors, 5 objections, I wanted to offer, in the spirit of trying to resolve 2 of the issues, the access issue and the utilities issue. There's a long legal history associated with those. If Mr. Young's concerns are simply to ensure that he has access and utilities to his property, the applicant is willing to accept a permit condition that we will follow the legal process if and when we relocate the access and or the utilities. And we will offer that if he is willing to withdraw his objection to those two items.
I'll just speak for Mr. Young, and then Bob, if you want, you can chime in here. The devil's going to be in the details on any proposal like that. So we're not prepared to withdraw any of our objections at this point in time. We're certainly willing to entertain any reasonable offer from the applicant. If we want to talk offline, we don't need to necessarily do this during this pre-hearing conference. But access is a serious concern, and what may be acceptable to the applicant may not be acceptable to Mr. Young.
Well, we do have some specific language, and we do think this is kind of a venue to try to resolve these issues as best we can before we take them to the hearing. So I do think it's appropriate to discuss here. So we would be willing to add a specific condition that states if or when a relocation of an easement is needed as a result of ongoing quarry operations, AFS will follow the proper legal process at such time to relocate the respective easement. So that would encompass all the easements that are a part of the access, that have access. So that's the language we'd be proposing.
Yeah, I mean, that's just an offer to follow the law, which you're already required to do. So I don't think that necessarily moves the needle here in terms of resolving this issue conclusively. But we're willing to further discuss this going forward.
Yeah, Mr. Lasik, it sounds like the proposal is to have it part of the permit, a permit condition. So it's not just follow the law, but if they don't follow the law, it becomes a permit violation subject to enforcement action by the division. And obviously, the parties can discuss offline, and if you're able to resolve it before the meeting, just let the board know when we introduce the pre-hearing, the proposed pre-hearing order, and happy to strike any issues that you do resolve in the interim.
Understood.
Okay, thank you.
Okay, any other issues with the specific objections?
Bob, is there anything else that you wanted to bring up, or did we cover everything?
I feel like we've covered everything.
Thank you.
Okay, so moving on, at this point, we're going to go ahead and establish the board hearing process. And what this will entail is the actual order that the board will, that this item will be heard, and the timing in which they'll be heard. And so before we get into it, specific timings and orders, I will say that generally the hearing order we follow the same kind of order. We can deviate and we can discuss that, but generally it's going to be an introduction. That introduction is going to be brought forth by the division, and it's simply going to be basically what Peter just laid out. It's just going to be for the board's knowledge. It's going to be, here's the permit, here's the number, here's the amendment we're working with, we've received objections, that kind of thing. So the division handles that introduction. And then after the introduction, it moves into presentation. Each party will have some time to do their presentation. It's going to be the all three division objectors and applicant. After the presentation, it goes into a rebuttal where you can rebut the information that was brought forth during the presentation. And then finally, there'll be a closing to kind of wrap up your case. Generally, the order that we do this in will be, like I said, the division will do the introduction. Then the following order for the presentation is generally the division, the division, the objectors, followed by the applicant. Same order for the rebuttal, simply, and the same order for the closing, simply because it's the burden's on the applicant. So that they generally go last on these. And so, generally with the division going first, the introduction, then they can go right into their presentation, and then they'll be followed by the objector and then followed by the applicant. So if that order is acceptable with everyone, like I said, it's an introduction by the division, presentation with the division, the objectors, then the applicant, then rebuttal by the division, then the objectors, then the applicant, and then closing by the division, then the objectors, then the applicant. Is that order acceptable to everybody? Do you want to change things? How's that sound?
That's acceptable to the applicant.
Okay.
That's fine with the objector. Is there any opportunity to rebut anything that potentially could be raised during rebuttal that is new? You know, just in the event of a new issue that comes to light during the applicant's rebuttal, we would just like to have the opportunity to respond to that briefly in the event that something new comes up.
Chuck, do you want to answer that?
I mean, that usually doesn't, I don't know that I've had that happen. Typically, rebuttal is limited to rebutting what was already said. But I guess if something did come up, you felt the need to address, and you still had some time left in your allocation, just ask the board for it, or maybe bring it up in closing. You know, it's fairly informal. It's a fairly informal process. You know, so if there's something you feel like you need to address, you know, bring it up to the board, and it's ultimately their call, but they tend to err on the side, at least in past, of getting all the information that's available to them.
Very well, thank you.
Jason and Chuck, just a quick question on the presentation order. I thought the order was typically that the division presents first and then the applicant presents their application with the objectors going third. And then there's a bit of a shuffle as we kind of carry through. Is that not the typical board process for presentations? Again, I don't have a preference. I believe that's how we've handled the last few permit applications before the board.
Sure. I mean, that's fine. We could do that. And I'm sure it's changed over, but like I said, the last one that I have is a division objection applicant on all three, but it's up to everybody. I mean, if you want to change it, Jeff, or anyone, then we can discuss it.
It may be more a question for the applicant and the objectors if they have in a particular position on kind of who goes first or second in the presentation after the division goes.
So speaking on behalf of the objector, I think it probably makes logical sense for the objector to respond to the applicant's presentation. I think that will make for a better presentation to the board as a whole. And it's otherwise you kind of have two sections of rebuttal rather than dealing with the applicant presenting its case, its carrying its burden on its application and then presenting the objections to that. So I do agree with Mr. Fugate that process probably makes more sense for both presentation and rebuttal.
Yeah, and the applicant would prefer the order as proposed.
As proposed, in that you would go third, would go.
No, as initially proposed, with the division and then the objector and then the applicant.
Yeah, I know we've done it kind of both ways in the past. I mean, I don't have strong feelings about it. At least in terms of presentation, I can see it making sense to have applicant kind of go right after the division, but particularly for rebuttal, I do think it makes sense to have the applicant go last, since it ultimately is their burden.
Okay, so what if we did that then? If we had in presentation, have the applicant go after the division with objectors, ending on presentation, but on rebuttal, leaving the rebuttal as is, where division followed by objectors followed by applicant. Is that acceptable?
That's acceptable to the objector.
Okay, is that acceptable to the applicant?
Yeah, so it would be division, objector, applicant for the rebuttal and the closing, but for the introduction, it would be division, applicant, objector.
Correct.
Okay, yeah, that's acceptable.
Okay. Great. So now moving on, we're going to get into timing. And just a reminder, there will be questions during this process by the board. Those questions will not be associated with your time. For example, if we have 30 minutes for presentation and the board stops you mid-presentation and has questions, those questions will not be added into your time. With that said, we have a few items on the agenda for this board hearing, I believe, but we'll kind of get into the timing, how much time we need to present, to provide rebuttal, and to close your arguments. So with that, we'll start in the order of this process with the introduction by the division. How much time does the division need for their introduction?
10 minutes is fine.
Okay, and then moving on now to presentation. How much time does the division need for their presentation?
30 minutes.
Okay, and then the applicant. How much time does the applicant need for their presentation? You're on mute there, Joel.
Yep, 45 minutes.
Okay, and then the objector for their presentation?
I think about 45 minutes as well.
Okay. And then we'll move on to rebuttal. How much time does the division need for rebuttal?
10 minutes.
And then the objectors for rebuttal.
Let's say an hour.
And finally, the applicant on rebuttal.
We'll go with an hour as well.
And then closing for the division.
10 minutes.
Closing for the objectors.
Say 20 minutes.
And finally for the applicant.
20 minutes.
Okay, let's see what they got here.
Mr. Music, Al Fry here again. Joel, do we want to talk about the untimely documents that have been provided and time be allowed to rebut those extra on top of what we've been allotted?
Yeah, I can tell you that in terms of this kind of board action, that time, any untimely objections or any comments from the public, that kind of thing, they're not going to be associated with this kind of board action in terms of this specific item. You'll have time, of course, to address those, I would imagine. Chuck can correct me if I'm wrong. But in terms of this particular action, I guess you would be responding to public comment but Chuck, you can.
Actually,
if
Mr.
I
Music,
might-
yeah, I'm sorry. What Mr. Fry is referring to is a document that the objector provided the day before the rationale was due. And it's very late in the process.
Oh, I see. Well, if it's not in the division's rationale, if the division didn't address it, then I'm not going to be putting that in as an item, a jurisdictional item that the board will hear. We can only go off that original objection, and that's the rationale, or that's the division's what the division's rationale is based on. I mean, you can correct me if I'm wrong, Jared or Peter. I don't think that we're going to put in this pre-hearing order as a jurisdictional item something that we received prior to a day before the rationale went out.
Yeah, and this is a geotech memorandum that was submitted the day before. So it is partly within the issue, but it is, late as far as any of the points that were raised in there specifically. There was no time for DRMS or for us, for that matter, to object or respond to any of those items.
I see. Jeff, you want to respond to what? I mean, I don't know. I would imagine there could be an objection to that. I'm not sure.
Sure. I mean, I want to make sure, Peter, we received the document prior to the pre-hearing. You're aware of the document being discussed here, correct?
Correct.
Yes.
Yeah.
Sure. Okay.
I believe it's listed on their exhibit, the objector's exhibit list.
Okay. I mean, I don't know the division has a particular position on whether it's should be admitted or not. I think that could just be something raised with the board and handled by the board when they're considering admitting the exhibits during the hearing process. Chuck, am I missing something? I guess could it just be an evidentiary objection raised at the appropriate time during the hearing?
Yeah, that's kind of what I was thinking. I'm not sure about the timing. I haven't seen the document. I mean, assuming it's something that's on the objector's exhibit list, I think that whether it's timely or not in terms of folks having had time to digest it and respond to it, it's probably something that would be best brought to the board's attention.
And I can't say for the record, and Jared or Peter, correct me if I'm wrong, because of the tardiness with which it was received, I don't believe it was considered as the division is working through its rationale, but I don't know that for sure.
No, it was received, right before the day before, I believe we issued our proposed decision. So we did not have time to review it before we did that.
And let me just jump in there. So the division's rules, there's no timeframes other than making sure that, all exhibits are disclosed and, listed on the exhibit list and then tendered both to the applicant and then to the division as well in advance of this pre-hearing conference. So everything that we're intending to introduce into evidence is listed on our exhibit list and was sent via share file this morning. If anybody has any problems with accessing any of the documents that are listed on that exhibit list, please let us know and we'll make sure that everybody has everything that we're intending to present. When that initial geotech report was served, the response that we got from the division was to do exactly that, was to tender it in advance of this pre-hearing conference, which is what we're doing. So to the extent that the applicant is requesting additional time to respond, we want to make sure that this process is fair and that everybody has the opportunity. We're certainly amenable to a continuance if the applicant wanted to request one. There's no need for us necessarily to go to hearing in 2 weeks if they wanted to present a rebuttal exhibit.
I don't think that's what we're asking for. I think we're just asking for maybe 30 minutes more during the hearing to have time to address it directly to the board. There's no need for a continuance in our opinion. We just want time, to actually address the 13-page geotech report that showed up last Thursday.
Yeah, Jason, I think kind of in light of that, maybe it sounds like what the real request here is to kind of amend the time allotments. And I don't know if folks from the applicant are envisioning doing this as part of the presentation or during your rebuttal section. I mean, it sounds to me, and I apologize for, sort of coming at this without knowing exactly what's in the document or its history, but it sounds to me like you're asking for more time during the hearing to address it. And, I think that's something that, if you need, so you've requested 60 minutes for rebuttal, if you wanted an additional chunk of time to do that, or if you think you have time within the 60 minutes, I mean, it really just kind of, it comes down to how much time do you think you need to address it? And, can we fit that into the time allotment that we're going to propose to the board?
Yeah, I think, we were looking at possibly through rebuttal, adding that time and Joelle and Al, correct me if you think otherwise, but I was thinking we would just add 30 minutes or to that, or we've got right now 60 minutes. What do you think, Joelle, now?
Let's just add 10 minutes for that.
Okay, so yeah, that's fine. So if we add 10 minutes to that, I just want to tell you where we are on time. So if we add 10 minutes to that, we're looking at a 4-hour and 20-minute board hearing for this item. And if somebody else added that different, let me know.
I think it was more than that. I think it's 4.5 or close to 5 hours.
I got 310 minutes, but I don't know that you want the lawyer doing math on something like this. And again, reminder, that doesn't include any breaks for the board. I think we'll get into some of the logistics of this hearing. So shuffling of parties to the hearing room and to conference rooms. And so it'll add some time there as well.
So I have a quick comment. It seems to me, and Mark, you can correct me if I'm incorrect, but it seems to me that they should address that report during their presentation versus during their rebuttal, because then it gives our side a chance during rebuttal to, address anything that we need to.
I think when they address it's going to be their call, kind of their preference. I don't think there's anything in kind of the format that dictates when people address particular evidence. It's sort of up to each party.
Yeah, and Chuck, I agree with that. That was kind of my thinking with regards to the possibility for rebuttal to the extent that there's something new that has been that arises, because right now with the current schedule, if it's the division, then the applicant, then the objector's presentation, and that's where the expert testimony comes in, and then the rebuttal goes to division, objector, and then the applicant. Then the applicant is essentially responding, rebutting what was presented by the objector, and then potentially rebutted, with then no opportunity for the objector to respond to their rebuttal to that expert testimony. So that was my concern about leaving something hanging there unrebutted.
Well, but I think that given the current order of the presentation, and it sounds like on your witness list, you have Rennie Konda, who is the author of that geotech report, will be presented in your presentation. And so we won't hear that presentation and know exactly where they're going with that until we get to rebuttal.
Yeah, understood. It's just that your rebuttal is before our rebuttal.
So then you have time to respond if our rebuttal is before your rebuttal.
No, our rebuttal is before your rebuttal. I'm sorry.
Correct. Oh. Yeah. We can go ahead and in our introduction, go ahead and address some of the concerns with that document, and so that the objector has an opportunity to rebut that.
So then, Joelle, would we want those extra 10 minutes put onto the presentation?
We could, yeah.
Would that be okay?
Well, before we start adding time on, I think we need to start figuring out a way to take time off. We're looking at a 5-hour hearing right now. So, and as Jeff said, this is going to be a situation where we're not all going to be in the same room. There's going to be room shuffling. There's going to be breaks for the board. There's going to be a lunch. And so we're also need to take into account other board items. So I think instead of trying to figure out where we're going to add time, I think we need to start figuring out where we're going to shave time.
Yeah, Mr.
5-hour
Music.
board hearing is a little much.
Yep, Mr. Music, I would propose for the sake of brevity and conciseness that if the objector is willing to reduce the introduction time from 45 minutes to 30 minutes, we would agree to match that. And with the rebuttal, if they're also agreeable to reducing from 1 hour down to 30 minutes, we would be willing to match that as well.
So rather than having the balance where the rebuttal is essentially longer than the presentation, I think maybe it makes more sense, at least from the perspective of the objector, that our presentation, because that'll include what we've been talking about with regards to the expert testimony, let's make that an hour, and then we'll move our rebuttal down to 30 minutes. So we're essentially going from right now we have an hour and 45 minutes. We'll move that down to an hour and 30 minutes. So we shaved off 15 minutes there.
Where else?
And then
so 15 here's, I mean,
how about we do 45 minutes for the presentation and 30 minutes for the rebuttal.
Yeah, that would be acceptable.
So we shave off an hour. So now we're down to 4 hours. Is that correct?
Correct. We could also reduce the closing statements from 20 minutes to 15 minutes apiece.
I think we can move down to 10 minutes on
closing.
I propose that for all the parties.
The division's at 10 minutes right now for closing. Do you propose
for the
10 minutes? 10 minutes for the objector. How about applicant 10 minutes on closing?
Yeah, 10 minutes will work for us as well.
All right, so let me read this back here. We got 10 minutes on the introduction by the division. We have 30 minutes for presentation by the division. We have 45 minutes for presentation by the applicant, 45 minutes presentation by the objectors. Then we have 10 minutes for rebuttal by the division, 30 minutes by the objector, 30 minutes by the applicant, and 10 minutes for all parties on closing. Is that correct?
Yep.
Sound right? All right.
Yes.
Did anybody add that up? No?
I got 3 hours and 50 minutes.
What I got too.
Well, good job getting it under 4. Very impressive. So
thank you everybody for doing that. So
yeah. So 3 hours and 50 minutes. Chuck, how do we feel on that time?
Do we know what else is on the agenda?
We do have some items and probably some at least one contentious item. I don't know all the other items. So so it's going to be it'll be a lot. So now, and just a reminder, these are, the board can adopt this draft order as they wish. If they look at 3 hours and 50 minutes, they might decide this is probably unacceptable, in which case they may cut your time. So my advice right now is you guys are in control of your time. So the last thing you want to do is go in there preparing for a 45-minute presentation and have the board cut it down to 30. And then you're cut short on the day of. So if you feel like you can do a 30-minute presentation and you can control that time right now, my advice would be to do it. If you feel like you can control a 20-minute rebuttal, now's your chance to do it. The last thing you want to do is get in front of the board and have the board shave that time when you're not prepared for it. So I'm just going to throw that out there. If you're good with 3 hours and 50 minutes and you want to take your chances, that's great. If you don't, then we can shave it now.
Yeah, I'll go back. I mean, we could do our presentation in 30 minutes.
Okay. Come on, Mark.
We'll match the
30 minutes, buddy. Good deal. Okay, so let's do 30 minutes on the presentations then. So we just saved half an hour. So let's do 3 hours and 20 minutes presentation. We all good? Great. Okay.
Yes.
I appreciate everybody doing that. I know it's a task, but like I said, now's what this informal conference is for, is for you guys to be in control of your presentations, on your rebuttals, and not have it out of your hands on day of. So I appreciate that. So here we are. We got 3 hours and 20 minutes. And what I will do is I will attempt to get that draft pre-hearing order out to all parties by close of business on Tuesday. That will be 5 o'clock, November 9th. And that will include, as I laid out the order before, it'll be the process, the order, the exhibits, it'll be who the parties are, and it'll be the timing. And so everybody will have that. If you see something wrong in that, then it'll go out to everybody. So if you see something wrong with it, respond and we'll get it amended if I make a mistake on that. But November 9th, close of business, you should have that. And this matter will be set for the hearing on the Mineland Reclamation Board on November 17th and 18th if needed, beginning at 9 a.m. I'm not sure in the order this will be heard, but it'll be, that's when the board hearing will start. Are there any questions on that?
We would just request that if possible that we this matter be addressed first after the administrative first items, understanding that we don't have control of that.
Sure. Okay. Thanks, Joel. Go ahead, Russ.
Just for I'm sorry, just for confirmation, is this going to be in person?
Correct.
Correct. Yeah. And this is Russ Means. I wanted to touch base on that. Please arrive and stuff at 1313 about 20 minutes prior to the start of the hearing. And what we'll have is protocols in place and stuff. The objectors will have a conference room and stuff where they'll be able to watch the presentations that are being done before the board, and then they'll have their opportunity to be live in front of the board. And the applicant will also have a conference room, and we'll have it set up and stuff where excuse me, and I swallowed something funny. We'll have it set up and stuff where a counsel can sit in at all times and stuff during the hearing if they prefer, or they could be in the conference room and stuff with their clients and stuff. That's fine and stuff. We'll give you the layout, but the most important thing and stuff is to be there and stuff about 20 minutes early so that we can get you kind of squared away there. And then go from there in that. So, but we'll have protocols in place and stuff so that there's room in the hearing room and stuff for opposing counsel, and then also for the president, those doing the presentation. So, but we'll have it all figured out. So, thank you.
So Russ, just to clarify, and Mark, I think I may have forwarded you my cell number in an email. If not, I'll get it to you if you want to call and touch base. I've not been able to speak with you if you guys had planned to appear in person or not. Our board has expressed a preference for in-person hearings on contested matters like this or large matters. And so as Russ described, we're going to try to make available conference rooms where you'll have screens and ability to interact with people in the hearing room, but for the parties that are presenting to the board, they'll be in the hearing room with the board members. There are still some restrictions at Department of Natural Resources for the 6-foot social distancing, which then impacts the number of people that can physically be in the hearing room at a particular time. And so there's going to be a little bit of kind of shuffling people in and out of the hearing rooms, but there's always going to be an ability to communicate with the hearing and watch the hearing and review people's PowerPoint presentations and everything else.
That is correct. Yes. Yeah.
So just a question for the process here, with regards to cross-examining witnesses. So let's just say the applicant is putting on a witness, and then they pass that witness, then the applicant goes into their conference room, and then the objector will come in and be able to cross-examine that witness.
Well, the number and stuff that'll be able to be in 318 and stuff, and that's why we're allowing for the opposing counsel and stuff and that to be in the room at the same time, but also and stuff that if there's an issue and stuff and that, you'll be in the other room and stuff, you'll be watching the hearing via Zoom, and you'll be able to raise your hand and cross-examine either through Zoom or in person in 318, depending on where you're at that time and stuff. So we'll work it out and stuff the best we can and stuff there. So, but yeah, if somebody has something and stuff and that you want to cross-examine on and stuff, you can come forward and stuff and that in person in 318, or you can also do it and stuff through at the conference room and stuff with your client and stuff by you.
Yeah, and to follow up on that question, likewise with objections on, exhibits or non-jurisdictional testimony, things like that. So at least opposing counsel will be in the room to timely object to that. So we won't have some of the delay that's happened with Zooms and things like that in the past.
That's correct. That's what we're trying to alleviate to the best of our ability and stuff. And that's why there's enough room and stuff there for opposing counsel to be in the room in person and stuff with the board and stuff and that to gain their attention right away. And the conference rooms and stuff are not that far away. So if we need to take a minute and stuff and that to allow counsel to come up from the conference room and stuff and that's not going to be an issue in that. But we'll address that and stuff and that as best we can. And we'll have staff and stuff there and stuff to help shuttle people around and get you into the right spot and stuff where you want to be at. So, and I imagine and stuff when we're doing the pre-hearing order, and that when the board adopts that, probably counsel and stuff will be up in the room, and you'll see the layout and stuff there. And we can have that further discussion and stuff if there's some concerns and stuff there. And that we can go from there.
Okay. And after reviewing the exhibit list that the objector provided, we do have some concerns, particularly related to 15 through 22, which are non-jurisdictional and outside the purview of MLRB, in our opinion. And so how will those be handled? Will those just go through to the board, or will that be addressed in the pre-hearing order?
I'll let somebody else answer that. So
every I can say that every item that was submitted as an exhibit will be in the pre-hearing order. It will be up to the board to adopt they can adopt it, and then it'll be up to, if something's non-jurisdictional, you can always bring it up from the board. Like I said, the five items that we addressed will be in the pre-hearing order, and that's what the board will look at to hear. If something's brought up outside of that, it would be up to the party to object.
Okay.
And we haven't in the past. I don't think we've had like motions in limine before, but you're free to raise the issue with the board either when the pre-hearing order comes up or sort of right afterwards, and tee it up for the board. Pre-hearing motions are, though the board chair does have the discretion to decide motions that are filed beforehand. Typically chair's not going to go out on a limb and do that on their own if it's something that's going to be contested. So take that for what it's worth. If there is an issue that you want to bring before the board and you choose to file a motion, likely it's going to get decided at the day of the hearing as well. So that's, unless it's something simple like you need a witness to appear by by phone or over Zoom instead of in person. Those sort of things are kind of pro forma and easy to deal. Anything that's more complicated and going to be contentious, the board tends to err on the side of having the entire board discuss it and make a decision at the day of the hearing.
Okay, and when will the pre-hearing order be available?
I'll like I said, I'll send that out. It should go out close of business on Tuesday, November 9th to all parties. It may go out sooner, but that's the latest it'll go out.
Okay, and in light of reviewing the Young's, the objectors exhibit list, there are a couple additional exhibits that if those are going to be allowed in, that we would like as rebuttal. Do you want those now, or can we submit those before the end of the day or amend our exhibit list?
Yeah, if you've got them now, it's fine. Otherwise, I think typically we've kind of given till the end of the day for amendments, or kind of get your exhibit list in by the end of the day.
Okay, thank you.
Russ, could we just get clarification? Is it understood that at least the applicant counsel, and at least one, land environment manager will be in the hearing the entire time?
During your presentation, there will probably be the setup and stuff for that will be there'll be 2 people at the presentation table and chairs and stuff for 2 additional members of your team, and then the council and stuff for that there'll be chairs and stuff that are behind that. And if say you have 6 experts and stuff in that, we have to keep it at that number. So someone would have to leave for somebody else to come in and testify and stuff, but you'll be there. And then, like I said, you'll be in the conference room and stuff very close by and stuff, watching it by Zoom. That's how we're trying to control the numbers and stuff there. So, but there's enough room and stuff in that for at least 4 people from your team to be there, along with the council and stuff that's on the side.
Thank you.
Okay. Are there any other questions?
I actually have 2 logistical questions. Just for our clarification, does cross-examination and objections erode against our allotted time?
Yes.
Okay, and it would just be specifically during either the presentation or the rebuttal, depending on when that cross occurs, correct?
Is that right, Chuck?
Yeah, and I don't think we've been super militant in terms of which bucket of time we took it from. It's it's sometimes easier for us who are keeping time, which is generally me, to keep track of it within blocks. But if we run into an issue where, let's say you had 5 minutes left over from presentation and you wanted to use that time in rebuttal, that's fine. I mean, typically what we want to do is keep it within the parameters and the general time frame that we've outlined. Obviously, I don't think it'd be ideal if we deviated substantially from that. If you took an hour and a half to do your presentation, it's probably not the best way to use all of your time. We would prefer that you try to stick to the times for each section that you have, but a few minutes here and there isn't really gonna make or break things. And we're, like I said, we don't have a flashing red light. This is not the Court of Appeals. We're not going to tell you to stop. We will remind you if you've used up all your time, but it's kind of at the board chair's discretion. And I don't know that I think Mr. Singletary is the chair this month, and I don't think he's going to have a stick to hit you with. So we'll work with everyone on time to make sure it goes smoothly, and that the presentation happens the way it should.
And then, since exhibits have been submitted electronically, but the hearing itself is occurring in person, do we need to provide the exhibits hard copy for everyone on the board and for witnesses, or do we not need to worry about that?
Well, the board's going to get copies of everything. It'll go in the packet. Cammie, the board administrator, puts those together. To the extent that you need hard copies to share with a witness, I'd recommend that you bring those on your own. We won't have those. We won't have binders of the parties' exhibits available for use, but the board members will have copies of the documents, and that's one thing. They'll be numbered sequentially in their packets with the page number, and I wonder if Cami, do you mind just shooting an electronic copy of the board packets, at least the numbering, so that all the parties can be on the same, literally on the same page when they're referencing?
I always do.
Yeah.
I send it to everybody, so that way we are all on the same page, literally.
And will there be a screen to, if we wanted to call out a specific exhibit, say like a photo or something of the site that we can project for everybody to see, and then, use a pointer or something like that to kind of direct people's attention to?
You'll want to bring a pointer, because I don't have one of those, not one that actually works on our TV screens. And then also bring a flash drive with any presentation you're going to share with the board. So that way they can see it too.
And Mark, yeah, there's two big TVs in the hearing room. So the board will have the ability to look at any exhibits you want to put on the screen, PowerPoint presentations. Cami, correct me if I'm wrong, is one still going to be reserved for online folks? Like, is one screen reserved for the Zoom access, or are we going to have both screens available for showing
That's
exhibits?
something that me and Susan, I think, are going to work on. We're just kind of trying to figure it all out ourselves. We'll probably, if we can, we'll go ahead and utilize the screens for presentation. But I can't be 100% guaranteed on that right at this particular moment. Hopefully here within the next week or so, I'll know.
But there'll be at least one large TV screen that the board members in the room will be able to see.
Correct. Absolutely.
Thank you. And then will there be, is there a kind of shared laptop at the podium there that will, move the PowerPoint presentation forward if we were using something like that, or should we be loading this on our own and then, hooking up when we get there?
Yeah, no, just bring it on a flash drive, your presentation, and then it's hooked up. The TVs are hooked up to the computer system. And so I'll be able to put it on the TV screens. You guys can open it up, and then you can just flip through it with the keyboard that's in front of you.
Okay, great. Thank you.
Mm-hmm.
Okay. Are there any other questions or comments? Great. Well, if not, I just want to let everybody know that it's much appreciated going through the process. That's what we're here for. So, like I said, the pre-hearing order will go out, close of business on Tuesday. And if you have any questions on that, you can let us know. But
Jason, before you sign off, and sorry, I just thought of this now. If the parties are able to communicate and have further discussions on a potential condition of approval related to the easement issue, if you could loop me in, that way I want to make sure that if you are able to reach agreement on a condition, that it's something that we can actually add to a DRMS permit, that we're not including a provision in our permit that we cannot enforce or deal with. So just keep me in the loop on any discussions you all have on that issue.
Okay, we will.
Thank you.
Great. Thanks, Jeff. Well, I think that concludes this pre-hearing conference. And once again, I appreciate everybody's time.
Okay. Thank you, everyone.
Thank you, Jason.
Thanks, Jason.
Thank you.